Hi and welcome to this Elevate Founders expert session on getting the legals right. We have Nigel from W Legal, which is based here in the City of London. Nigel for many years has worked with some of the biggest corporates in getting their documentation, their legals right. And it's so important from an early stage of a business to get those documents right. Enjoy.
My name is Nigel Kushner. I'm the CEO of W Legal, a London-based law firm. I'm here today to talk to you about contractual pitfalls in your terms and conditions. Some of the things that I'll talk about have been used by perhaps disingenuous people to shaft others. Other things I'll talk about are things that I have found to have protected clients. I'm going to go through about 10 different things that you should look out for when you are reviewing terms and conditions provided by others, or which should be in your terms and conditions. Depending on whether you are the seller or the buyer will depend whether you want to include some of the things that I'm going to talk about. I'm going to start off with some of the most important things that one should look for in any contract. The first one sounds a little bit silly, but it is the parties. Who are you contracting with? I often get past contracts where someone hasn't paid, and I look at the contract and think, who is my client going to sue? And there's no proper company name. There might be something similar to the company, but if it is not the correct company title, XYZ Limited might be the correct title, but you might find the contract just says X, Y, and Z. Who are you going to sue? The answer is you'll have a problem, because XYZ Limited will say, well, we weren't the contractual counterparty. We're XYZ Limited. This contract is issued by XYZ. You may then point to someone in the company who has signed the contract, and they'll say, well, that's not a director. We didn't authorize him to sign it. So the very first thing you need to check is what is the full name, the company name of the entity with whom you are contracting, and always slot in their registered office address. The second thing I'm going to talk about is the law clause, which is critical. You can have the best contract in the world, but if it doesn't say which law will apply, if you need to enforce your obligations or sue for payment, you may have a problem. Everything will be fairly straightforward if you have an English company selling to another English company. But what if you're selling to someone in Europe or outside Europe? Well, I'll tell you exactly what will happen if you have a problem. You will end up having a fight for months, perhaps years, over which law will apply. Will it be English law? Will it be French law? Will it be US law? It's very, very complicated. So you need to agree your law clause. I would naturally suggest that English law applies to your contracts. It's generally very well regarded around the world. And there's another reason why you'll want English law. Because if you're drafting your terms and conditions in accordance with English law, you don't want another law to apply. For example, let's imagine you're selling some goods to someone, and there may be a risk that there could be a quality issue with the goods, and someone wants to come and sue you and says, you've sold me a dud. And let's, of course, imagine you haven't sold them a dud. You might have a wonderful set of terms and conditions which says something like, if you have a quality claim in relation to the goods I have sold you, you are obliged to notify me within 15 days of your receipt of the goods. Under English law, that might well work. Under Swiss law, that might well work. But if you have US law, for example, US law says you cannot simply put this type of time limit in your contract, and in fact, your buyer can claim within a reasonable period of time after receipt of the goods. And any clause that says anything different is not worth the paper it's written on. So choose your law clause carefully, and of course, if you don't have English law, go to a lawyer who is qualified to give you a view on the law of the contract. What about jurisdiction? People talk about jurisdiction clauses. What that means is, well, you've agreed which law will apply, but how will your disputes be dealt with? You have a number of choices. You could insert a clause saying that the English courts will have jurisdiction in relation to a dispute, or the law courts of another country. It's generally sensible to have the same law and jurisdiction clause with the same country. It would be a little bit absurd, although I've seen it, to say the English High Court will determine the dispute, but it will be subject to US law. You can incorporate that, but it will be incredibly expensive to actually run a case. Another option you've got is arbitration. What's the difference between arbitration and, say, the English courts? Well, arbitration is generally private. You don't get your dirty laundry aired in public, whereas court proceedings are open to the general public. You can turn up to any court any day of the week and sit in a trial and listen to what's going on, as can journalists. Arbitration does tend these days to be more expensive than the English court system. Sometimes you have to pay a percentage of the claim amount, which can of course be very high depending on the value of your contract. In the courts, anything that you're claiming which is £200,000 or above will be subject to a £10,000 issue fee. But aside from that, any further payments to the courts will be minimal. Arbitration can sometimes be quicker than the English courts, but there's not a lot in it. In an international context, it can sometimes be easier to enforce an arbitration award rather than an English High Court ruling, for example. Next, beware rolling contracts. What's a rolling contract? I enter into an agreement with you for 12 months to provide a particular service for a particular agreed fee, except hidden away in my horrible terms and conditions, as the unscrupulous lawyer I might be, I add a clause which says, by the way, this contract will continue year on year unless you terminate it 3 months in advance of each year end, which means if I sign an agreement with you in January, it's going to end in December, but if you don't terminate it before the beginning of October, it's going to roll over for another year, and on the 1st of January you might think it's terminated, but I'll be asking you for a full annual payment. I've seen that happen, and it can be very costly, so read the terms and conditions very, very carefully. Next, payment. Payment in full. You want a clause in your contract if you are selling goods which says you must pay in full regardless of whether you have any claim against me. Let's imagine you're selling goods in 5 deliveries over 5 months, and there is a dispute about the goods that you sold in month 3. Come month 4, you might find that the buyer just says, I'm not paying you, I've got a quality claim for the goods that you sold me in month 3. What you want is a clause which says something like, you must pay without offset or deduction whatsoever, payment in full, regardless of whether the contract is being performed in tranches or not. That will protect you. I see people fall down on that regularly. What about claims? If you're a seller of goods, you really want to have a robust clause which protects you. Of course, you're going to deal with sensible claims in a sensible way, but you don't want to give a disingenuous buyer an ability to wriggle out of payment, delay things, and bring claims against you in relation to what he says are quality issues. It's your word against his. And I'm afraid you do have some unscrupulous buyers who do this day in, day out with different sellers. Then they go on to the next seller and they do the same thing. How can you help protect yourself? Well, you could put a clause in your contract which says that if there are any claims in relation to goods, then it is the buyer's obligation to inspect the goods, and he has 14, 21, however many days you want to give him, but set it out in writing in order to bring a claim, and if he fails to do so, then he is barred from bringing a claim. In addition, if there is a claim made in relation to goods and it's notified you within the relevant time period, then those goods must be set aside, cannot be used further, may be capable of being returned to you at the buyer's cost, and if he fails to do so or fails to provide an inspection report or allows you to inspect, then again he loses his rights to bring a claim. Of course, you will deal with claims seriously, but this will put you in a much stronger position if people try to play games with you. Next, I'm going to talk about force majeure. What is force majeure? It's something that was not foreseeable, which was beyond your reasonable control. So if you've contracted to do something or to provide certain goods and you can't do so because there's been a hurricane or a strike, or you couldn't get the particular raw materials that you needed in order to produce the goods you're making, you might be able to claim force majeure. And what the clause will say is that if something unforeseeable beyond your control occurs which prevents performance of the contract, then you are relieved of your liability. You can't get sued. You never know when you might have to rely on such a clause. But be careful with the clause. I see some clauses which say that a seller might be relieved of liability if he is hindered or impeded in performance of the contract. That's quite a low bar to be hindered, sort of like you've got a bit of a problem. I see other clauses which say it must be impossible for you to perform the contract. So just choose your language very carefully. You'll also need to think about what the consequences of the force majeure event might be. Some clauses say that if it continues for a period of 3 months, then the contract is deemed terminated with no liability to either party. Another clause, if you're a seller, that you might like to insert is what we call a retention of title clause. So if I sell you some goods and you happily take them and conveniently forget to pay me, the retention of title clause says, even though I have sold you the goods and given them to you and they are on your premises, ownership is retained by me. I retain title to those goods. And in theory, if you haven't paid me in accordance with the contract, or in particular, if you go bust and become insolvent before you've paid me, in theory, I can march back into your factory or premises and I can take my goods back because they still belong to me, and a greedy liquidator won't be able to get his hands on them and sell them. I'm now going to talk about perhaps one of the most important clauses that a seller will require in his contract. And of course, if you're a buyer, you might resist and you'll be saying the opposite of what I'm saying now to a seller. If you're selling goods, you want to limit your liability so far as is possible. There's 2 ways to limit your liability. One way is to limit the types of claims that can be brought against you if you sold something. For example, you could exclude certain types of claims for what we call indirect losses. What would an indirect loss be? If you've sold something to someone that they're going to use in a machinery and the machinery blows up and something else is damaged as a result, that would be an indirect loss. Or you might want to exclude liability for loss of profit that would have been made by the buyer had the contract been performed in the way that was anticipated. So you can limit your liability in that way. You can also limit your liability as to the amount that can be claimed. You could say that your liability is limited to the value of the goods. You could say liability is limited to £5,000. Whatever you want, and frankly, if you're a seller, whatever you can get away with. One thing you should never put in a contract is that you're limiting your liability for death or personal injury, because the law says you cannot limit your liability in that way. And one thing to watch out for when you're generally drafting terms and conditions or clauses is that if you've got a clause that's 10 lines long saying 10 different things, if one of those 10 things in your paragraph is deemed by the court to be unreasonable, then the courts might strike out the whole clause. That's why when you sometimes see terms and conditions, you have lots and lots of little subsections, so that if one subsection is deemed by the courts to not be fair and to be struck out, they won't strike out the rest of the agreement. So if you think about it, if you had this amazing limitation of liability clause that limited all types of damages, that reduced the amount that could be claimed to £100, you'll think fantastic. But if it also doesn't expressly allow claims in relation to death and personal injury, then the whole clause might be struck out and you'll have lost everything. So just do be careful. Another type of clause you see in terms and conditions is what we call an entire agreement clause. Often you can have negotiations for days, weeks, or sometimes months, and I've also seen negotiations taking years in relation to contracts, and all sorts of promises, representations are made in the contract negotiations. You want to sell something. One would hope you won't say anything that is a misrepresentation, but things can also change from the time that you start to prepare a contract to the time it's actually signed. So we often have an entire agreement clause. What does it say? It says this contract that's in front of us that we've both signed contains the terms that we've agreed. No one is going to rely on anything that anyone said that is not contained in this agreement. That can be quite important if you're a seller. Of course, if you're a buyer and you've received all sorts of representations, you might challenge this clause. Or if there's something that's specifically been promised to you or represented that's important to you that isn't contained in the contract, slot it in, that this is a representation that has been made. Battle of the forms. What is the battle of the forms? Let's imagine you come to me and at a very reasonable rate I prepare some perfect terms and conditions for you that are very suitable for your business. You think, fantastic, can't go wrong now. Well, you can because of the battle of the forms. What does this mean? Let's imagine you send out your lovely contract with your terms and conditions. And those terms and conditions say, this is the contract, these are our terms, we don't deal on any other terms, these will apply, regardless of what happens in future. Let's imagine the next day the buyer comes back and says, thank you very much for your contract, we're agreeable, but here's our standard terms of purchase from you. Thank you very much, we're delighted that we're now contracting with you. Let's imagine nothing else happens, you sell the goods, you get paid, and there's a problem. Will your terms and conditions mean anything? No, they will be meaningless. And the reason they're meaningless is because you have lost the battle of the forms, the battle of who gets their terms and conditions in last before there is contract performance. What you should have done is go back after you sent yours and they sent theirs, and you should have gone back and said, thank you very much, but I'm afraid we will only contract on our terms. Here's our terms again. These apply. If you want to deal with us, we'll be delighted. And it will go on, and sometimes you can have many rounds. The person who wins is the person who gets the last word in before there is contract performance. And don't think that you can just send terms on your invoice. It's too late. You can't do a deal with someone and then after you've done the deal and performance has been commenced, you can't force new terms that haven't been discussed on anyone. People often think there's an advantage in sending their terms and conditions on the back of an invoice. It's neither here nor there. Finally, I'm going to finish off with personal liability. Startups sometimes start up with someone acting on their own, in their personal name, rather than a company. And that makes sense for a lot of reasons sometimes, but be so careful. If you've got a house, if you've got assets, everyone has something. If you're contracting in your own name or through a trading name, you're personally liable and on the hook for anything that goes wrong. So you really need to limit your liability, and as soon as practically viable, set up a limited company. There's a reason why people use limited companies, and that is because it invariably protects you against personal liability. And a final thought, and I've seen this inserted in contracts, and it's not necessarily legally binding, but it can sometimes be very persuasive. Let's imagine you're selling to lots of different companies. You get a new purchasing company come along, they promise you the world, they sound fantastic, but they are not. They're crooks, they didn't pay, they never intended to pay. Or they're about to go bust and they just can't afford to pay everyone. I've seen clauses in contracts which say something along the following lines. If you are a limited company or a partnership and you fail to pay, you agree that the director or partner of the business is personally liable to make payment. Now, you can bet your bottom dollar when there's 10 people to pay and they can only afford to pay 2 or 3 people. If you've got a clause like that in your contract, which you can throw back at the person who thinks they're smart enough to avoid paying, they'll probably put you to the front of the queue. Thank you very much for listening to me, and I hope that moving forward in the future, you will now have more robust terms and conditions, and if in doubt, pick up the phone.
Thank you so much for watching this episode, and I really hope you enjoyed it. If you did, please subscribe and please comment below and tell us what you want more of these expert sessions on. We will go and find the experts. Thank you too to Runway East for letting us use these offices to film in. If you're looking for shared workspace to grow your startup from, I would highly recommend you use them. They're based in London and Bristol, but they're expanding fast, so do check them out. And thank you for watching.